After Leon Valley, Texas Police Chief Joe Salvaggio filed a complaint about Councilman Will Bradshaw for criticizing officers, the establishment councilors scheduled a removal hearing against Bradshaw. Bradshaw filed suit against the city administrators and councilors to block this hearing. An emergency restraining order was granted, which blocked the hearing for several weeks. However, to halt the removal hearing throughout while the litigation was pending, a temporary injunction would need to be issued. The case was referred to a United States magistrate judge to hear the facts of the case from each side and to make a recommendation on whether or not the injunction should be granted. This video is the full testimony from that hearing. Following the hearing, the magistrate judge issued a recommendation that an injunction be granted. And on Friday morning, the district judge issued the injunction to block Bradshaw's removal. As you watch this video, feel free to leave a timestamp comment for later reference and to help other viewers know which parts they should listen to first. This video will show you how important these city officials think they are, and that their city rules and ordinances trump even the Constitution. And certainly at the local level, where you have the local government club, the justice or injustice system is generally at the county level, and you have this club who protects each other, can retaliate against their opponents, protect themselves regardless of the law, doing whatever they want within this system so often unchecked. Perhaps things will be different now that the federal court system is involved. To keep up with the real news and investigative reports about government corruption, please subscribe to my channel and enable all notifications. I hope you enjoy this public record that I purchased for you to hear.
Hold on.
Bradshaw versus Salvaggio et al. Essex 20 CD 1168.
Good morning, everyone. I'll have appearances, please. First for the plaintiff. Which attorney is making an appearance for the plaintiff? Oh, I am.
Judge, you're on mute.
I gotcha. Good morning, everyone. I'll have appearances, please. First for the plaintiff.
Good morning, Your Honor. Solomon Radner. I'm here on behalf of the plaintiff. My local counsel and full counsel in the matter, Brandon Grable, I see is present as well.
Thank you. And for the defendants?
Charles Frigerio, representing the city of Leon Valley.
Okay, thank you. And I know that we have a few folks on the line who are members of the public, and I just request that you all keep your videos off and your microphones muted so that there's no interruptions to the proceedings today, just as if you were sitting in the gallery of the courtroom. It looks like we also have, in addition to my law clerks, some of the parties have separately called in. So is everybody, Mr. Radner, is everybody who you're expecting to be on the call for your side here as far as you can tell?
From my side, yes.
Okay.
There is another witness, though, who is subpoenaed, who I don't see here yet, and that's Mayor Chris Riley.
Okay. Mr. Frigerio, are you expecting anybody else to be joining the call?
No, Your Honor, but the mayor has been aware of it, and I've been in contact with her, and she does have the link. So.
Okay. Well, we can, I suppose, get started and then see how things go in terms of calling witnesses and that person's availability. I don't know, Mr. Radner, if somebody is, or Mr. Frigerio, if somebody from your team is in contact with and attempting to confirm the mayor's availability at this time. Okay, well, we're here today on a motion for preliminary injunction. I have some of what I requested prior to the hearing. I did not really have a full and complete response from the defendant, but I assume we'll address most of it today on the record. I don't also see proposed actual injunction language from the plaintiff. So if that's something that would normally be submitted prior to a preliminary injunction hearing. But I've reviewed all the filings that we do have, and there's a preliminary matter to take up, which is the fact that Judge Beery, referred this to me rather than holding this hearing, and so it creates a little bit of additional procedural complexity. Of course, the issue is that the temporary restraining order has an expiration date, but under the rule governing my jurisdiction, if I were to grant or deny relief, either or recommend that either of those rulings is subject to a 14-day objection period, and so we're a little bit out of sync in terms of the objection period and the TRO's expiration date. And so, under the federal rules, the parties by agreement can agree to, extend the status quo or not. And so I'm wondering, here before I hear any evidence and before I make any rulings, if the parties have discussed or come to any agreement about how to handle that, for instance, by agreeing to an expedited objection period, for instance, or just agreeing to, honor whatever is recommended up until the time that 14 days expires, so that you have an endpoint. Mr. Radner, your thoughts?
Very interesting. I wasn't really prepared to argue that particular point. My general thoughts are, I think what you asked was kind of twofold. One is any discussions that I've had with defense about how to deal with this, and then specifically how we would deal with any objections to an R&R that the court would order. Do I understand what you're asking me?
Right, because, you all could agree, you just have 14 days to object, but the party who doesn't like the ruling, or in fact sometimes both sides object to whatever I recommend, depending on if, I recommend some of what you want and not all of what you want. And so, you could all agree to an expedited objection period, which would then tee up the R&R to be accepted or rejected by the district court more quickly, which appears to be in both of your interests. You've both been arguing for, a decision to be made more quickly rather than more slowly in this case. So I was wondering if you would agree to that, Mr. Radner and Mr. Frigerio, your thoughts as well. I'll hear in a second.
So, Your Honor, I would agree with an expedited briefing schedule, particularly for objections. The thing that I would, I guess now that it's brought up, the thing that I would want to make sure of is that, given that we're only dealing in 14-day chunks, that the TRO remains in effect until Your Honor's R&R is decided. I think that Judge Berry extended it, but I don't know how much longer it's going to last. I probably should have had that pulled up in front of me.
Should be the 30th.
Screens, and today I only have one. I'm sorry, what's that, Mr. Frigerio?
I think it's the 30th of October.
That sounds about right. So I don't know how long this hearing is going to last. I don't know if we're going to be able to wrap it up today, or if, given the number of witnesses and exhibits we're likely going to have, it might be that the court's going to need more time, or that the parties are going to need more time. I also don't know how the court's going to want to deal with proposed findings of facts and law, or if the court's just going to issue it on its own. But my main goal here is there's an elected official who's about to get thrown out of office. Once that happens, this case is effectively dead because he can't get that seat back. The city has already proven that with what they did to Mr. Martinez, which I argued in my papers, and I'm sure Your Honor has read it. But the solution that I've offered is that the city can go ahead and do what they want. They can hold their hearings, they can have their investigations, even though my client's not allowed to be represented by counsel, and even though it's First Amendment protected conduct, they can go and do whatever they want to do, so long as they agree to not throw him out of office, which seems like an extremely extreme sanction anyway, given what the allegations are. They have not agreed to this. I think the reason for that is kind of obvious, and it kind of underlies the need for this entire case and for the TRO. But that's the solution that I've offered. I think it's a very reasonable solution. Go ahead, do what you want. Just don't throw him out of office 7 days before an election.
Okay. Mr. Frigerio.
I hear you again, Judge. You're muted.
I I don't know how that happened. I didn't think I muted myself. So, Mr. Frigerio, my question then is, what is your thought and your client's position? I mean, at a minimum, would your client just agree to, I guess, regardless of my ruling, preservation of the status quo pending the expiration of the objection period? So basically a 14-day extension from today, if I were to rule today.
We would agree to an expedited objection period, but we will not agree to allowing, after the 14 days, which is October the 30th, we're not agreeing to extend it.
Okay. All right. So you would agree that that everybody will file their objections. I mean, basically, you would need a ruling, at least an oral ruling from me today. Confirm. Obviously, I'll be doing written findings because I'm required to make certain findings in writing in this context for the district judge, but that you all would have to get your objections on file on or before, I assume, the 30th. Correct?
Yes. Yes, Ron.
And Mr. Radner?
Yeah, that'd be fine.
Okay. All right. Go ahead.
If we get our objections on the record, no matter which way you rule, the judge may not rule on those objections, even if they're before him on the 30th, until the election, which is going to be too late at that point. So there's 3 whole days for the defendants to throw my client out of office.
I mean, there are some things within my control and some things not within my control. I do not have any control over what Judge Beery will or will not do, but I do have the ability to at least put him in the position to be able to accept or reject the R&R as of the expiration date of the TRO on the preliminary injunction issue. And I think that then it will be up to Judge Beery what he wants to do at that point.
Fair enough.
Okay. All right. So the application for preliminary injunction is yours, Mr. Radner, and I have reviewed the briefing, and I think I understand the primary bases of what you're requesting. And your introduction suggests to me that that really the injunctive relief that you're asking for in terms of what needs to be preserved pending a full trial on the merits is just that the plaintiff not be allowed to be removed, right? So, because there are other issues in here about the extent of process that's required, if he were to go through the city's process for removing an elected official, whether or not the process that they engage in, which may or may not allow witnesses, may or may not allow cross-examination, may or may not allow him to present evidence. You're not asking all that to be resolved in this posture, just the question of whether or not he can be removed?
Ultimately, that's the relief I'm seeking, but we can't lose sight of the fact that in order for me to get there, there's 4 elements that I have to convince the court of at this juncture, one of which is that this is basically a meritorious claim, which means that my client's due process rights are just being trampled on. So that is something that we're likely going to have to get into because I have to show that it's a meritorious claim. And that we have
right.
a strong
well, you have due process, but you also have your First Amendment claims.
Right. So. That's kind of what I was all-encompassing constitutional rights. But yeah, so we have to show that in order to get an injunction to not throw him out of office, I have to first show the court that we have a good likelihood of success. As I understand it, and if the court disagrees, then the court's probably right.
Okay.
That's my understanding.
All right. So are you ready to call your first witness then?
I really would like to be. I kind of made a little bit of a mistake here, and there was a Dropbox that the defense sent me, I think yesterday. And every time I get Dropboxes, they almost always just go straight to my some filter, spam or trash or something, because I get so many of them. And then I tried opening it this morning, and I couldn't get in because it was the wrong. It was my email address, but I usually open it on my Gmail account. And then I went on and created an account. Ultimately, I did get the documents. I have them in front of me, but I haven't had a chance to review them, and they are apparently somewhat voluminous. I'd like an opportunity, not a very long one, because I understand that this was an emergency hearing that's being held at my request, and I don't want to push the court off too much, but I'd like an opportunity to just review these documents if possible, and then maybe 15, 20 minutes, and then I'll be ready to call my first witness. Would that be acceptable?
Mr. Bergerio, this is the agreement that you filed an advisory about in terms of the documents produced in response to the subpoena duces tecum?
Yes, Your Honor, and we received some early this morning. The bulk of them were received and reported to counsel Monday. He received some today. I have no objection to him reviewing the ones received today from the mayor.
Okay. Well, do we have, and in that time frame, do we have the mayor? It does look like we have the mayor on the line now. So is that going to be the first witness that you call, Mr. Radner?
Most likely the first witness I'm going to call is Mayor Riley, unless there's something in the documents that surprises me. That's my plan, is to call Mayor Riley, and then probably Catherine Rodriguez, and then we'll kind of play it by ear.
All right. So, Mr. Bergerio, any objection to a 15-minute recess for Mr. Radner to look at the mayor's documents then?
No, Your Honor.
Okay. Well, we'll recess for 15 minutes, and I will recall the case. Everybody on the call is welcome to put their videos on to turn them off and to mute their mics. And we'll get started in 15 minutes. Thank you. What is going on right now?
Documents. I didn't realize how many documents there were. It's almost 200 pages and 4 videos. And I've downloaded some
Mr. Radner, hold on 1 second so we can get back on the record.
Oh, okay.
All right, we're back on the record.
Okay, thank you, Your Honor. I've reviewed some of it. I'm still downloading some of it. And it's 195, it looks like it's 195 pages of bait stamps. No, I'm sorry, it's 191 pages of bait stamps and 4 bait stamped videos. And I haven't even downloaded all of it yet. I've reviewed some of it, and I'm just wondering if we can have until 11 o'clock.
Well, Mr. Radner, here's the issue. We're in a preliminary injunction posture, and this is not, a full trial on the merits. This is a chance for you to put on evidence that there is a reason to enjoin the defendants from acting for an abbreviated period of time up until the time that we can have a more robust and complete hearing and get into all of this. It seems to me that you've got a few different issues in your case, but there's this one distinct issue is actually the First Amendment retaliation issue. And the application you filed indicates that your argument is that your client was engaged in some, form of protected speech, and that the attempts to remove your client were motivated by engaging in protected speech, and that that's improper. Do you have evidence that goes directly to the question, the relief you're asking for in this posture, which is just to be prevented from removing your client for the time being, pending more robust proceedings. Do you have evidence on that point, or is that what this evidence goes to?
I have evidence on that point. It's the actual body cam footage of the speech.
Right, and that's already in the record because there was at least a publicly available link to that I saw. So what is it that we're delaying the hearing for?
So what we're delaying the hearing for is, and again, I'll defer to the court on exactly the best way to proceed here, but my understanding of what I have to show the court right now is that there's a procedural, or there's either a constitutional, procedural, or substantive defect, constitutionally speaking, that we are going to win on. And it's not just the free speech issue, it's also on the procedural and substantive due process issues. For example, they want to have a hearing where my client's not allowed to ask any questions or have a lawyer represent him.
You don't believe that's a distinct claim from your First Amendment claim?
No, I think it is, but I think that that's also one of the bases that would grant us relief. Let's say the court looks at the video and says it's not constitutionally protected. I could still demonstrate to the court, well, there's also a procedural and substantive issue here, constitutionally, and therefore we're entitled to relief under that. That's why, without knowing where the court is thinking, my position.
Well, Mr. Redner, I haven't heard any evidence yet. So, I mean, this is the problem. And now we have been waiting for, I mean, you've had up until, the TRO was extended for an additional period of time. This is a longer period of time than normally is permitted in these cases and in this posture to prepare for a preliminary injunction hearing. And so I can certainly recess until 11 o'clock for you to go through more, but I'm asking, I guess in order to be entitled to the relief that you're asking for, you do not have to prevail or show likelihood of success on all of the counts you've alleged. You have to show that you can prevail on a count that would entitle you to preliminary injunctive relief, right? I mean, so, right. I mean, I guess I cannot tell you how to litigate your lawsuit, but in terms of the relief you're asking for today, which is preventing the removal, the question is, was there a First Amendment, was it protected speech, right? Did your client engage in protected speech? And, do you have evidence that suggests that the defendant's behaviors were motivated by that? I guess I can ask Mr. Progerio, there's been no briefing from your client's position on how it is not protected speech. I mean, how is a person who's elected to be on the city council expressing an opinion about whether or not the behaviors of other officials are proper or improper? Is that not quintessentially political and protected speech?
Your Honor, we did, in our motion to dissolve, we had the case out of the Western District of Louisiana that talked about a school board individual that was being taken off the board. And in that case, they held it was constitutional because there was an independent investigation, which we have in this case. It wasn't just...
But that was a due process argument. This is a First Amendment argument.
Your Honor, I did also find there's a case that I had shared with counsel this morning. It's the case of Suarez versus Silva at 2020 Westlaw 2543311. It's out of the Fourth Court of Appeals. It's akin to this case in that it was a case out of the city of Congress, which is also a suburb in the metropolitan area. It had a very similar, almost identical ordinance as the one here in Leon Valley. And that case went to the Fourth Court of Appeals. There was a TRO granted and a preliminary injunction granted. The preliminary injunction was appealed to the Fourth Court of Appeals, and they reversed, holding that the ordinance was constitutional.
Which case was that again?
Suarez, S-U-A-R-E-Z, versus Silvas, S-I-L-V-A-S. It was decided May 20th of 2020. I
mean, so there's two separate issues going on here, though, right? There's one question, if a city council member engages in some, let's just call it misconduct or inappropriate conduct of some form, there are due process rights associated with being elected to a position, and therefore due process issues that arise if that office is attempted to be, if he's attempted to be removed from that office without proper due process. But in this case, we have a different issue because there's a separate constitutional basis that they're challenging the behavior on, and that is it is protected First Amendment speech. It's not always the case that something is protected First Amendment speech. For instance, I think in the other case that's been talked about related to this particular city council, whether or not the allegations are true or false, and I don't know anything about them, that person was accused of sexual harassment. Now, sexual harassment is not protected speech. And so it might be a separate question of whether or not the guy got his proper process in being removed for that allegation. But here, my question is, are any of the cases that you've cited cases where somebody has engaged in political speech, and that is the allegation is the attempts to remove him are based on engaging in political speech? Because that's what makes this case different.
The one, Your Honor, although counsel portrays it that it's a removal, it's a 312 hearing. There has been no determination what will occur at that hearing. Independent counsel that was hired would present that case. But in the Silva's case, the issue is not whether the issue is communication, inappropriate communication with a city employee. That's what we have here. It's not our position is not a question necessarily of the First Amendment. It's a question of how that First Amendment was exercised by a governmental official. So we have a city councilman who comes out and is talking directly at officers who are in the city hall outside the chambers. That is interference.
So I have, I think, a transcript. We're talking about the language where the plaintiff says to the arresting officers, you guys are disgusting, you disgust me, you're the problems with this country, you're the problems, you're the guys that are kneeling on people's necks, I'm sorry, but this is disgusting, you arrested a 7-year-old for assault, that's disgraceful. That's the comments we're talking about, right?
Directed to the officers, yes.
They're directed to the officers. And so I guess my question for you is it your position that that is not political speech?
No, it is not. It's interference with the officers' duties.
How did he interfere? Did he, other than saying those words, did he do anything that prevented the officers from being able to do the arrest?
The arrest was already effectuated, but the commenting to a city employee and basically telling them that they had not performed in accordance with their duties is a criticism what you're not afforded to as a councilman. If he had a problem with the way that individual was arrested, his duty was to go to the city manager and complain, but not to go directly to the employee.
Okay, so that's your position. Your position is that even though, you know, in the ordinary sense of things, you know, people expressing their opinion to officers as they do their job, that they think they're behaving disgracefully and inappropriately, whether or not I agree with it or you agree with it. I mean, you'd agree that generally that is protected speech in our country. People are allowed to say that.
Correct.
But you're saying he cannot say that to the officers while they're doing their job because he's a councilman?
Because he's a councilman. That's specifically why in the summary investigation done by Keith Sikowski, which is part of the record in this case, he also found as an independent investigator that he was harassing the officers doing their job. And that was something that should be brought up to the council.
Well, and you understand that, like, generally speaking, organizations, governments, and everything else can have rules about harassment, and that's, you know, employers have rules about harassment, but there are rights that people have that you can't. If the content of the speech, if what he is saying is what makes it harassing in your mind, you can start to have applications of legitimate harassment policies that infringe on people's First Amendment rights in some circumstances. Not at all, right? I mean, so you can have a policy, it could be fine on its face, if when it is employed in a particular instance, it is employed in a way that infringes on constitutionally protected speech, then that can be a problem. And I think that's whether or not that's the argument that we have here. So I'm asking for whether or not you can point me to any case law that would support your position that an elected official, you know, can be required to sort of confine his opinions on this particular issue to the avenues that your governing charter, I guess, prescribes.
Well, again, the City of Converse case, Silva, is where the councilman.
And do you have the site for that case?
Yes, Your Honor. It's 2020 Westlaw 2543311.
We'll
Justice Alvarez. We're dealing with...
Go ahead. It's Brandon Grable. I reviewed that case, and to your point, Judge, it has nothing to do with protected speech. It talks about communications that occurred outside the charter, but it has nothing to do with protected speech, which I believe was your question.
Okay.
Here.
Okay. All right. Well, let's. Mr. Radner, are you still requesting your break?
Well, Your Honor, here's what I'm going to do at this juncture. What I'll do is based on where I believe the court is going with this and how the court views this issue, what I'd like to do is I'd like to present the video to the court, and then I believe at that juncture it'll be appropriate, potentially. I guess nothing prevents me from asking for a directed verdict at that juncture. Be a strange. I don't think there's anything procedurally that bars me from doing that. If the court grants it, then we're done. And if not, then I can proceed with the testimony and focus on the other issues that I think give us injunction, give us a right to have injunctive relief at this point.
Okay, well, I don't think it'd be a directed verdict in the context. I think what you would be asking for is for me to grant your motion for preliminary injunction and to prohibit the city council from removing your client pending a more in-depth, review of evidence and future hearings on the other issues or a merits trial. There's
That's exactly it.
Yes. So if we can watch the video. I have the one that was already, I think, linked. I've seen portions of, but you can play it now for the record, and we'll take it from there. Okay, go ahead, Mr. Radner.
And this is base number 1 provided by the defense, and this is the video. And something that I'd like the court to take judicial notice of, please, is that my client is actually outside of City Hall, acting as a regular citizen when he makes these statements. And I'm playing it from 250 into the video. It's page stamp number 1. I imagine we'll probably label this as Exhibit 1.
It's shameful. It's shameful. It's really shameful. You choose this opportunity to do it. Dusty, you're the problems with this country. You're the problems. You're the guys that are dealing up. You know what you I'm sorry. You seem like a young gentleman, but we saw what you did during Mr. Martinez's hearing to get up there and try to slander a councilman.
And I'm pausing it now at 3:20. Your Honor, I don't think anything really needs more to be said here. At this point, I would ask the court, based solely on this video, to find that this is quite clearly and obviously free speech. There's just no question about it. This is quintessential free speech.
Well, I don't think that the record that you've just put before me shows me anything other than what he said in that particular video. I don't know, for instance, who's being arrested, what's going on with that arrest. So do you want to go ahead and put on your client and ask some questions so that I can have a record?
Yeah, I can put my client down and do that. Okay, at this time, I'd like to call Mr. Bradshaw.
Hello, Your Honor.
Hello. I'm going to go ahead and put you under oath. If you could raise your right hand. Do you swear or affirm under penalty of perjury that any testimony you may give will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Go ahead, Mr. Radner.
Thank you, Your Honor. Good morning, Mr. Bradshaw. Can you please state and spell your name for the record, just so that we have it?
Yes, my name is Will Bradshaw, WILLBRADSHAW.
And you are a city councilman, is that right?
Correct.
One thing that you and I have in common. And you are currently under investigation for criticizing the police in your city, is that right?
That is correct.
Okay. And why don't you tell us about the facts and circumstances surrounding that critical speech that you engaged in on the night that it happened. Tell us what had just happened and why you chose that time to engage in such speech.
So that evening, it was a very long city council meeting, as tends to happen lately in Leon Valley. I believe it was in excess of 6 hours. And it got over at 1:30, approximately 1:30 in the morning. And after the meeting, it had been adjourned, there was a citizen there during the meeting that was very critical of the majority on the council and the city manager and the police chief. And next thing I know, I'm collecting my laptop and my bag and stuff, and I see he's being arrested in the outside of council chambers, just in the foyer. I see he's being placed under arrest. I didn't know the reason for his arrest. I just know, like I said, that he was very critical during the meeting of the council majority, and then all of a sudden he's being arrested at 1 o'clock in the morning. This was also, a little background on my comments, this was the week that all the media was being on the news, obviously, about George Floyd, about the George Floyd incident where officers had knelt on his neck and he died. So all of this going on, obviously, is kind of the basis of my comments. But, it was upsetting to see somebody who was critical of the council and of the city manager and the chief of police being arrested. And, of course, at that time, they said they had a warrant for his arrest. I didn't know the details of that warrant at that time. I didn't know what it was for or why he was being arrested. I just know that it was obviously upsetting to citizens and upsetting to myself.
Let me interject with a question here. Was this the first time you had seen the chief of police arrest somebody who was critical of him?
No.
That's something that happens with some regularity in Leon Valley, isn't that right?
That is correct.
And you were aware of that at the time that you made these comments?
Yes.
And how would you say your relationship is with the chief of police at the time that this happened?
Objection to relevance, Ron?
Well, it goes to what his mindset was at the time and why he was engaging in the speech that he was engaging in.
I'll allow it.
So since the very first day when I started to run for office, the police chief came onto my property and moved my political signs. He moved them. I have a fairly large yard, an acre and a half, and the rules that I said that the political signs could be 2 to 3 feet from the curb or the street. I don't have curbs in my neighborhood, but we have streets, and he moved the signs 17 feet into my yard so that they were now behind trees and rocks and not very visible from the road. That was my first real interaction with the chief of police.
Okay, and since that time, you'd criticized them for other things, isn't that right?
Correct.
Yeah, criticizing the chief of police.
I'm sorry, what's the objection?
It's overruled.
Okay. Since that time, you've criticized Chief Salvaggio, isn't that right?
Yeah, so as I was running for council, I would go around the neighborhood and ask people what their issues are with the city and tell them that I'm running to represent them. I didn't have a whole agenda. I just said I want to represent the citizens and see the citizens need. And I was made aware of the towing policy of junk vehicles in Leon Valley. And I checked the police chief when I was first elected. It was one of the first or second council meetings it came up. A citizen came and complained about the towing of vehicles from their private property.
I'm gonna step in because this is something that, if necessary, I can get into with the chief. I have the minutes that you're referring to, where he kind of misrepresented the state statute about junk vehicles. But since that point in time, aside for the junk vehicles and aside for him coming onto your property, you were openly critical about him specifically for punishing people for engaging in free speech. Isn't that right?
That is correct.
Okay, in fact, I guess we can tell the court that I'm representing about a dozen of those individuals who were engaging in free speech. That case is still being litigated, so I don't want to get into it. But you knew about me from that case. Is that right?
Right.
And that's why you reached out to a lawyer in Detroit.
Right.
Okay. And in that particular case where a dozen or so people were arrested for protesting and filming outside of a police station, you were critical of Salvaggio there as well, correct?
Right.
Okay, and that took place in the summer of 2018.
Correct.
Okay. Now, you and Chief Salvaggio obviously have had a relationship that's been marred by some acrimony. Is that fair?
That is fair.
Have you subsequently learned who the so-called alleged victim was of the assault for which Mr. Yarnell was arrested in the middle of the night?
Yeah, so like you said, I didn't know at the time what this charge was. They said they had a warrant. I later found out that the warrant was, in fact, an alleged assault by Mr. Yarnell that was issued by Councilor Charles. I'm sorry, Councilor Alcacer, which happened a year previously.
And you witnessed that supposed assault, correct?
Yes.
Okay. Without getting into the facts and details of the case.
Yeah, supposedly after the council meeting.
He was arrested. Mr. Yarnell was arrested on a warrant.
Right.
Whatever his opinion is about what the incident underlying the warrant is irrelevant.
Well, you can get warrants for anything. Not that.
Mr. Renner, I will overrule that objection. I don't know whether it's going to be relevant. I don't also know when the warrant was issued. So go ahead, Mr. Bradshaw. What did you witness?
Yeah. When is it that you learned? When was that warrant issued? How far before the arrest was the warrant issued? Do you know?
Off the top of my head, I believe it was several months prior.
Okay. And Mr. Yarnell had never been notified, hey, you have a warrant, you might want to come in and get a rain down, right?
Correct.
And Mr. Yarnell is also an outspoken critic of the police chief, is that right?
That is correct.
Okay, now, the police chief, while you may be critical of him, there was another person who was also critical of him by the name of Benny Martinez, is that right?
That is correct.
And what happened to Benny Martinez?
What do you mean, as far as with the police incidents or getting kicked off the council?
Getting kicked off the council. Who threw him out of council? Which three people were involved?
Objection. Are we going to now litigate another councilman under a 3 of 12 hearing that has no relevance to this case?
Pattern of practice, Judge. These people have a pattern of practice of retaliating against people for exercising their constitutional rights.
Well, the reason that I'm going to allow it is because I think it's relevant to the issue of whether there's irreparable harm.
Thank you. Mr. Martinez was removed from office, is that right?
That is correct.
And who is the person who made the complaint against Mr. Martinez?
The original complaint was the same one who's making the complaint against me, Councilor Catherine Rodriguez.
Defendant, Councilor Catherine Rodriguez.
Correct.
Okay. And she made the complaint against Benny Martinez, and she's also making the complaint against you.
Correct.
And who are the people that voted to throw Mr. Martinez off of council?
Donna Charles and Monica Alcacer.
And how quickly was a replacement sworn in so that the only way to litigate it was quo warranto?
At the next meeting, immediately they chose one of their friends to replace him on council.
And that person's name?
Matthew Hody.
Now, David Jordan, who's not listed as a defendant yet, but is subpoenaed as a witness, is the chairman of what board?
The chair of the Ethics Committee.
Ethics Committee that's currently investigating you.
Correct.
Now, David Jordan and you have a history as well, don't you?
That is correct. He was my opponent during my election.
And you beat him, right?
That is correct.
How many years ago was that?
That was in 2018.
Okay, so 2 years ago you beat Dave Jordan.
Oh, sorry. It was, when was it? It was May of 2019. Sorry.
Okay. May of 2019, you beat Mr. Jordan, and now he's the chairman of the committee that's looking to throw you out of council, right?
That's correct.
Okay. And the other people who, whether he ultimately recuses himself or not, the other people on the board all have signs for whom on their yard?
They are all supporters of Catherine Rodriguez.
Catherine Rodriguez, the same person who levied the complaint against you and against Mr. Martinez.
That is correct.
Have any of them indicated whether they're going to disqualify themselves from trying to get you thrown out of office?
No.
And by the way, why is it that you think that the goal here is to get you thrown out of office? Maybe they just want a century.
We see a pattern of them trying to maintain control, the majority of the council, whether it be an election or through getting rid of Mr. Martinez, they try to stack it in their favor to always keep the majority.
Okay, and all three of those people right now, the three who are involved in throwing Martinez off and the three that are trying to throw you off, Alcacer, Charles, and Rodriguez, all three defendant councilors, all three of them are on the ballot next week. Is that right?
That is correct.
Okay. Has defendant Rodriguez made public statements to people that her goal is to get you thrown out before that election?
Objection, Your Honor. Hearsay.
It's not hearsay. She's a defendant.
Overruled.
I've been told by citizens that is the goal.
Okay, well, that may be. Okay, let me ask you something else. Defendant Rodriguez also made comments to you about throwing off a different member of council, right?
Objection, leading, Your Honor.
Sustained.
Okay. You had conversations with defendant Rodriguez prior to a different councilor being thrown out, right?
That is correct.
Why don't you tell us about that conversation?
So when I was running originally, before I even filed to run for city council, I had several citizens kind of encouraging me to run for council, because I was attending the city council meetings and paying attention to what's going on in the city. And I was invited by a citizen to come to a meeting of concerned citizens and out at a bar in Pelotas on a Sunday afternoon. And so I went to that. And at that meeting, there were several citizens there, including Councilor Rodriguez. And at the time, she mentioned that they had a plan for Benny, referring to Benny Martinez. They had a plan for Benny Martinez. And at the time, I didn't think anything of it. I didn't know what she was talking about. But a few weeks later, she filed her ethics or her complaint, her official complaint for a 312 hearing against Mr. Martinez, which led to him being kicked off.
Okay. And as far as irreparable harm goes, if let's say the court were to let the TRO expire on October 30th, the election doesn't happen until November 3rd. When is it that the new council would be sworn in? Do you know?
At the next city council meeting, once the election has been validated.
And when would that be?
Results.
What date, do you know?
Let's see, November. We have a meeting. So the 17th, I believe, is the next regular council meeting. November 17th.
November 17th. So if the TRO expired before November 17th, how quickly could possibly, based on the current rules that are in place, how quickly could you be thrown out and somebody else, maybe Dave Jordan, sworn in as your replacement?
Based on the past experience, they would call a meeting, probably an emergency meeting, to call a new counselor in my spot. They would have an executed 312 hearing, kick me out of council, and then call a meeting to replace me.
Okay. And one last thing, just which goes to the irreparable harm here. There was a meeting scheduled for last night where the ethics committee, led by David Jordan, who you beat in the last election, was going to be overseeing a complaint against you. Is that right?
That is correct.
Now, I want to ask you a couple questions about that. There were some other complaints that were made that have not even been investigated yet. Is that right?
Yes, for a 312 process. I don't know about the ethics hearing, but for the 312 hearing, that is correct.
I'm sorry, I didn't understand the testimony. The meeting took place last night, or it didn't take place last night?
I asked one question, he answered something else. So
okay.
Let's not talk about that right now. I'm talking about the meeting that was supposed to happen last night with the ethics committee. Dave Jordan was supposed to chair a meeting that was going to consider making a recommendation to throw you out of council, right?
I don't know what their recommendation would be.
Yeah, that's not a question, Mr. Radner. Can you ask a question?
Yeah, the ethics committee was supposed to meet last night to talk about you, right?
That is correct.
Okay. Even after the TRO was in place, correct?
That is correct. Yes.
And then yesterday morning, thankfully, at what time did they cancel it and adjourn it to Thursday?
It was probably around 10 or 11 o'clock. I don't know.
Okay, 10 or 11 o'clock. And as of right now, it's currently scheduled for Thursday, which is October 29th.
That is correct.
Before the TRO even expires. they're planning on taking an action which ultimately could, it's step one of multiple steps, the last one of which is you potentially getting thrown out of office, correct?
That is correct.
Okay, now, let's go back to what you were telling us before. The 312 hearing that they want to have on you, which thankfully the court entered an injunction stopping them from doing so. How many other ethics complaints had been filed before yours was scheduled for a hearing?
So I think maybe misunderstanding. It's not ethics complaints that were filed. I don't know if there's other ethics complaints, but the other complaints are supposed to be 312 hearings.
I apologize. 312 complaints. There were, how many other 312 complaints were filed before Rodriguez filed hers against you?
So there was a recommendation to hold a 312 hearing against the mayor, and there was a recommendation to hold a 312 hearing against Donna Charles as well by this council.
Have either of those been scheduled?
No.
After those two were requested, somebody apparently in the majority decided that you're more important and cut the line. Is that right?
That is correct.
Okay, so now yours is scheduled days before an election, but those two still have not been scheduled.
That is correct.
Okay, Your Honor, at this time I'm prepared to pass the witness. I think I've made how I plan on proceeding clear.
Just because we have a lot of evidence that got filed before, can you point me to where in the record, I think it's one of the defense exhibits, but where in the record is the complaint against Mr. Bradshaw?
Exhibit 2, Your Honor.
Exhibit 2 of your exhibits? Okay.
Yes, Your Honor.
Okay. All right, Mr. Ratner, you're prepared to pass the witness?
I am.
Okay. Go ahead,
I'd like to reserve the right to recall him if we...
well, you can engage in a redirect examination limited to the scope of whatever Mr. Frigerio covers on cross.
Okay.
Mr. Bradshaw?
Sir?
You were supplied a packet of documents which included a memorandum by Keith Sikowski, the independent counsel retained by the city of Leon Valley.
Yes.
And he also had it was on a flash drive. It had different videotapes, correct?
That is correct.
And the memorandum by Mr. Sikowski detailed the allegations that he found supportive of a 312 hearing against you, correct?
Yes, there was a memorandum.
At this time, Your Honor, which has been marked as exhibit number 1, I would offer that into evidence, Your Honor.
Okay. Any objection, Mr. Radner?
No objection.
Okay. It's admitted.
And as part of that...
Sorry, I think you cut out there for a second. What was your question? As part of that?
As part of the documents that were provided to you, Mr. Bradshaw, there was a complaint by Chief Salvaggio and 2 other officers, correct?
I believe so. That's correct.
And that has been marked as deposition exhibit number 2, and I will offer that into evidence, Your Honor.
Any objection, Mr. Radner?
No objection.
Okay. That's admitted too.
And Mr. Bradshaw, you are familiar with the charter of the city of Leon Valley?
Yeah.
And in the charter under Article 3.12, there's a hearing that can be conducted by the city council.
Correct.
That has been marked as exhibit number 3, and I would offer that into evidence, Your Honor.
Any objection, Mr. Radner?
No objection.
Okay. Exhibit 3 is admitted.
Mr. Bradshaw, you are aware of the fact that part of the ordinances of the city of Leon Valley prohibits employees, or it really prohibits anyone from harassing employees of the city of Leon Valley, correct?
Are you talking about? I don't know if the charter says that.
The city ordinance.
The city ordinance about harassment.
Yes.
Yes.
In the document which has been admitted by the court as exhibit number 1.
Okay.
The ordinance 1.12.011, paren 1, paren A, provides in part as follows. This is part of exhibit 1 I'm reading. Harassment becomes unlawful when the offensive conduct causes intimidation, an antagonistic environment, and or is offensive to a reasonable person. The conduct can include, but is not limited to, epithets, slurs, and negative stereotyping, threatening, intimidating, or hostile conduct, denigrating jokes and comments, writings or pictures that single out, denigrate, or show hostility or aversion toward a city official or employee that interferes with the work performance. Conduct, comments, or innuendos that may be perceived by others as offensive are wholly prohibited. That is the conduct that has been displayed in the video outside City Hall chambers as harassment. Do you agree that you were harassing the City of Leon Valley police officers?
No, I do not. I don't agree. I didn't use any racial slurs or epithets or derogatory comments towards them.
Are you fully aware as a city council member that you also have duties to not interfere with city employees' work?
I am aware, and I did not tell them to stop what they were doing or to not arrest this person. I didn't interfere with them with the arrest or try to stop what they were doing.
You were criticizing them, were you not?
I was criticizing the process as a whole.
You did not know at the time that there was a warrant for Mr. Yarnell's arrest, did you?
I did know. They said that there was a warrant. I took their word for it that there was a warrant, but I didn't know what it was for.
And are you aware of the fact that if there's an active warrant for an individual that an officer has a duty to arrest that person?
I am aware that they have a duty to do that. I still question why it had to be at 1:30 in the morning after a council meeting when everybody was there. This council meeting started at 6 p.m. and Mr. Yarnell was there about that time. I don't understand why they didn't arrest him when they saw him if they had a warrant at that time.
Are you familiar with the ordinances of the City of Leon Valley that if you have a criticism of a city employee that you are to bring that criticism to the city manager?
I think that's for the employees. For council members, our senior head of the council is the mayor. So if we have issues as council members, we are to bring it to the mayor.
You're not to bring this. You're not to directly address city employees, are you?
There is a kind of ambiguous phrase in our charter that says employees shall deal with employees solely through the city manager, which I have a problem with that in our charter, because shall deal with employees only through the city manager. To me, that means if I get pulled over by an officer in Leon Valley, am I not allowed to ask them any questions? Am I not allowed to talk to them? I need to call the city manager there if I get pulled over. It just it's very ambiguous.
Would you agree with me that you as a city council member should not be harassing city employees?
I agree that, in the terms of harassment, which to me is sustained, continuous, I don't believe that I harassed anyone.
But if someone was to believe that you did harass somebody, you understand that you don't have the right to harass a city employee even though you're a council member, correct?
I'd agree with that.
Thank you. I'll pass the witness around.
Mr. Radner?
Yeah, are you saying that based on the ordinance, it would be illegal to, let's say, call a police officer the N-word?
You're asking me?
Yeah. Mr. Frigerio was just asking about whether you're allowed to use racial epithets, so let's say it straight out. Are you allowed to call a police officer an N-word, or are you going to go to jail for that?
Objection. Leading, Your Honor.
I don't know that it's leading, but so you can. I don't see how it helps you, Mr. Radner.
Well, I'm going somewhere with it.
Okay.
I would say that is constitutionally protected free speech. I personally would not do that, but I do believe that people have a right to free speech.
Okay. Does free speech, as far as you know, have to be factually accurate?
No.
So whether you know there's a warrant or not, does that weigh on in your head as to whether what you're allowed to say is permitted?
Okay, Mr. Radner, he already said that he knew there was a warrant. Can you move on?
All right. I don't have anything further at this time.
Okay.
Nothing further, Your Honor.
All right. Are you going to call your next witness, Mr. Radner?
Well, Your Honor, as we kind of talked about before, I'd like to ask the court to make a ruling at this point if we've prevented enough that this is quite clearly free speech. You saw the video. You saw what the speech was. You heard from Mr. Bradshaw about the facts and circumstances surrounding that free speech. I mean, if that's enough to throw somebody out of counsel, we got a real problem here. If the court's not prepared to rule on that, then I can call more witnesses and focus more on the due process elements of my complaint.
Well, let me ask Mr. Frigerio some questions. Mr. Frigerio, is it? Let us start from this scenario. Do you agree that there is some category of speech that council people can engage in that's protected by the First Amendment?
Yes, Your Honor.
Okay. And assuming that I know that you might disagree, but assuming that what Mr. Bradshaw said in this context falls within that, the city, it would violate the First Amendment for the city to remove him for engaging in that speech, correct?
If the speech was not harassment, but there's a difference between having a right to the First Amendment and having consequences. So if someone calls...
Okay, so that is true. And you have a harassment definition that you've put forward that I will have to make a decision on whether or not his speech qualifies even under that. But a harassment policy can sometimes even be unconstitutional as applied. I guess my question here is, you seem to be treating Mr. Bradshaw as if he were a governmental employee who has a narrower right to speak on issues than maybe a public citizen would. Like, for instance, a deputy who reports to the police chief might not be able to express his political opinions at work in every context, correct?
Your Honor, I'm not trying to say he's an employee. I'm saying by the fact that he took an oath to be a city councilman, that he has certain duties. And some of those duties are that if he has a problem with any city employees, to go to the city manager. But he's not to directly address. And that's what the Silva case also talks about. Because the city council person tried to directly interfere with the duties of the work.
Okay, so I have the Silva case, and I can take that. I can certainly look at that more clearly. But that's the case that you think is the case that is your best case on why somebody engaging in protected First Amendment speech can be subject to removal proceedings for engaging in that speech. That's your...
Yes, that case, Your Honor, in Harris versus Monroe City School Board, which we cited in the motion to dissolve. And
why do you think what he said... I mean, I heard you read the definition of harassment from your city ordinance. It's, obviously there were no epithets. This isn't something that has a racial charge or a sexual harassment connotation or anything like that. So what aspect of what he said do you think qualifies it to meet the definition of harassment under your policy?
I think under today's standard, when you talk to an officer and say you're the kind of people that put your knees on some people's head, you're making a direct disparaging comment to that officer. Obviously, it was it's not obvious perhaps, but it wasn't peaceful of us. But you're criticizing an officer by saying, the worst thing you could probably say against a police officer for doing his job. That's harassment.
Okay, so in your opinion, Mr. Bradshaw is not allowed to say critical things, even if he doesn't interfere with the officer's ability to do the arrest or anything else. He's not allowed to say critical things directly to officers from Leon Valley because he's a city council member. That's your position?
Yes, Your Honor.
Okay. And you don't think that there are any First Amendment limitations on that?
I think if he has a problem with the way the officers are before me goes to the city manager. That's the way it should be according to the charter.
Okay.
Can I call a witness, Your Honor, before you make a ruling?
Absolutely, you can call a witness. I just wanted to clarify for purposes of what is before me today, what's distinct between the First Amendment and the due process things that are also at issue in this case, and I think are not quite as time sensitive as the First Amendment and removal issue. So go ahead, though, and call your first witness.
I would like to call Keith Sikowski, but I didn't know if the plaintiffs have rested or...
So what we're going to do, really, is sort of bifurcate this into two steps. There's going to be the First Amendment, likelihood of success on the merits and irreparable harm, and all of that analysis that I'll do preliminarily. And if I can reach a ruling on that would warrant recommending injunctive relief be granted in terms of preserving the status quo, we can continue, and since everybody seems to have documents and things that have just been produced, we can continue and have the due process issue handled at a later date if we can decide this preliminary issue. If your witness results in my concluding that Mr. Radner is unlikely to be able to meet his burden to prove likelihood of success on the merits and everything else under the First Amendment claim, then we may have to move on to the due process issue today. But go ahead and call your first. Mr. Radner, do you have any other witnesses to offer at this time on the First Amendment issue?
No, but I'd like to reserve the right to call rebuttal witnesses.
Yes. Go ahead, Mr. Pacherio.
I need to contact the witness, Your Honor, if you could give me 2 minutes.
Sure. We'll take a 2-minute recess. Thank you. Do you have the recording off, Val? Mr. Frigerio, you're on mute, but there you go. Do you have your witness?
I have emailed him, and I'm not sure if he's on. I've informed him to get on.
Okay. And who is the witness?
Keith Sikowski? Yes. Are you on? Keith, are you on the Zoom?
I see a person waiting. I'll get my deputy to. It says, can you ask if he's using Sarah Smart's phone?
Sarah Smart, I believe, is not Keith. She's a different lawyer.
Okay.
Yeah, that's not her.
I've been informed, Your Honor, that he's in the process of connecting.
Okay.
I believe he's on.
Mr. Frigerio, can you call your witness and then I can...
Yes, Your Honor. Keith Sikowski?
Mr. Sikowski, if you are on the line, can you unmute your line and your video? There you go. Mr. Sikowski, I'm going to go ahead and put you under oath. If you could raise your right hand. Do you swear or affirm, under penalty of perjury, that any testimony you may give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. Go ahead, Mr. Pacherio.
Would you please state your name for the record and spell your last name, please?
My name is Keith Sichkowski, then spelled Sieckzkowski.
And what is your profession, sir?
I'm an attorney
And how long have you been licensed?
since 1985.
And are you board certified in any specialty?
Labor and employment law.
And do you work for a firm?
I work for Branscombe PLLC.
And where is that located?
Well, I'm located in Corpus Christi, but the firm has offices in San Antonio as well.
Were you contacted with regard to an issue with regard to the city of Leon Valley this year?
I was.
How were you contacted?
I was contacted by Charlie Zech, Z-E-C-H. He's the city attorney for Leon Valley.
And what, if anything, did Charlie Zech request you to do?
He checked my background in labor and employment law, and my understanding is he submitted my name along with several others for possible consideration to do some work for the city. In the end, I was engaged to review a complaint on behalf of the city, and in particular it was a complaint against Councilor Bradshaw.
And what, if anything, did you do with regard to that investigation? What documents did you obtain?
Well, the engagement was under their charter, the Leon Valley Charter. They call for a potential investigation when there's a complaint. The procedure specifically requires that it be an employment lawyer if the complaint is against a counselor. In this case, I received, I think the day of or the day after the engagement was signed, a copy of a complaint that was from Counselor Rodriguez, Dr. Rodriguez, and that complaint listed a number of things, but focused on Mr. Bradshaw's conduct in addressing officers regarding an arrest, and whether or not certain violations occurred with respect to campaigning during council meetings. In this particular instance,
did you obtain any video evidence?
yes, I was just going to say, in this particular instance, everything is on video. The materials, there was a video that purports to be, well, it's a video of the arrest. It occurred after city council meeting. Purportedly, it is a video by Mr. Bradshaw. Really doesn't make too much difference because I was concerned more about Mr. Bradshaw's conduct as opposed to that particular issue. There were also several videos from police cameras on their body cams.
But besides the body cam video, there was also video you viewed from Mr. Bradshaw's cell phone?
Well, that was the first one. Mr. Bradshaw, presumably, that was a video of the arrest from inside of the council chambers. The council chambers at Leon Valley are very open. It's glass on one side, and so when you walk into the Leon Valley City Hall area where the council chambers are, it's just glass windows on one side, so you don't have to be in the council chambers to actually see outside or inside. So this was taken from inside the council chambers and a videotape of an arrest who had recently attended a council meeting.
And did you review any other documents?
Yes, and I reviewed, of course, the city ordinance and the city charter. I reviewed the other videos that I mentioned. I reviewed initially because I didn't have access to the police body cam video initially. So that was initially I reviewed a number of different things. I have them all out in my report. What I reviewed.
The report has been marked and admitted into evidence as exhibit number 1.
Okay.
You have no personal ties to the city of Leon Valley, I take it?
No. I know where Leon Valley is. I used to practice in San Antonio 25 years ago, but no.
As part of your investigation, did you look at the city ordinances that entitle city employees to have a workplace free of harassment?
Yes, sir.
Did you feel that was an important part of your investigation?
Yes, specifically in the complaint, Dr. Rodriguez had identified various things that she thought were violations, and that included the city charter and potential violations of city ordinance. So I did look at those specifically, and you were asking about documents. During the course of my investigation, I also reviewed and identified written complaint from the chief and
Chief Salvaggio.
Yes, the chief of police, and attached to his written complaint were various statements of officers, and the
that's
substance.
been considered for your purposes as exhibit number 3.
Okay, and the substance, for my purposes and what I was investigating, because Dr. Rodriguez's complaint was basically the complaint I was investigating, or the incidents. The statements didn't add anything directly to the investigation because the videos told it all.
I take it you did not. Did you do any interviews of any witnesses?
I didn't think it was necessary, no. There was a lot of colorful language in the chief's report about prior histories, so forth, but I was focused on just a simple incident, and that's what I focused on.
And what was your conclusion as to whether or not your investigation...
You said you were focused on a simple incident. You're talking about the incident where the other gentleman was arrested after the council meeting by the 2 officers, and Councilman Bradshaw made comments to the arresting officers?
Correct.
Okay.
And was that the focus of your report?
Yes, and I guess, I don't know if I'm allowed to pull it up. I'm at my computer at my office, I could do so, but the focus of my
exhibit number 1.
Okay.
Your report.
I can't see it here, so. The focus of my report was whether or not Mr. Bradshaw's conduct violated Home Rule Charter, and in particular, and in general, the Home Rule Charter limits, as most ordinances and city governance does, it limits council members from dealing with or instructing employees of the city. And so the question was whether or not Mr. Bradshaw's comments in context with the time and what occurred, whether or not he had violated that provision of the city charter. And I found that he did violate it by addressing the officers while they were performing their duties and functions.
Let me ask you this. Did you take into consideration the First Amendment, though, of free speech?
Yes. Whenever somebody does something addressing officers, you wonder about whether or not there's a First Amendment possibility. In this particular instance, let me back up a moment. It is common, and it's not a violation of the First Amendment, to restrict a council member's right to address employees that are properly managed by somebody else. In this case, it would be a city manager or chief of police. That's common, and that's known. The issue in this case was whether or not, in my opinion, Mr. Bradshaw was addressing the officers as a concerned citizen or as a council member. This happened immediately after council meeting, right outside the council chambers. Mr. Bradshaw hadn't left. He was still dressed in the same outfit that he wore during the council meeting. He still had his council meeting materials with him when he addressed them. And in one of the videos, I recall specifically, there's even a comment about the elected official. And he was the only elected official addressing the officers. So he was not divorced. This wasn't like a political rally or a demonstration on the street or something like that where he was engaged as a citizen protesting police abuse, if you will. This was addressing the officers immediately after they engaged in this conduct, about their conduct and about what they were doing. I could not divorce that and identify him as just a mere citizen expressing a view.
In your opinion, did you form an opinion as to whether or not at least that conduct by Mr. Bradshaw should be addressed at the 312 hearing for harassment?
The decision on whether or not to go to a hearing is really up to the city council. What I reported was that I believe there was a violation, and the city council decided to take that to a 312 hearing.
The violation you found was under Article City Ordinance 1.12.0111A that defines harassment?
Well, that's a different part, but initially it was whether or not he was dealing with dealing with employees. The second part was whether or not his conduct amounted to harassment under the city city ordinance. And I described in my report that the city ordinance is drafted pretty broadly as far as what constitutes harassment. And in particular, this ordinance says, after it says all employees will, that the city basically forbids harassment, it specifically says that people will be treated with respect and in a professional manner. I think objectively, I don't think that someone who viewed the videos would find that that was a professional response or that it was done in an appropriate manner. It clearly was problematic for me. In fact, one of the things that made it most problematic as far as being harassing is likening the police officers to kneeling on individuals' necks. The video of the arrest shows that it was done very professionally. There was no fighting, there was no arguing. It was just a very simple arrest. Nevertheless, telling the officers that basically that their conduct is the same type of conduct as kneeling on an individual's neck, when later, one of the things I reviewed, and this material was also provided to Mr. Bradshaw, in a city council meeting, he responded to his actions and stated very clearly that he knows of no incidents when the officers had acted that way. And yet he openly said, "You're the type of people that are kneeling on people's necks." Now, he said he was talking metaphorically, but I do employment law, and I can tell you that that is a very problematic statement to an individual.
Did you make certain conclusions in the last page, which is of Exhibit 1, concerning your objective review of the evidence?
I did.
And one of those, to save time and so you won't have to look at it, made 4 different conclusions. One, you said you believe Mr. Bradshaw's actions created an antagonistic environment. B, you stated his actions stereotyped the officers by asserting that they are people kneeling on people's necks. 3, Mr. Bradshaw's action in calling the officers disgusting and disgraceful was degrading under the circumstances. And 4, Councilor Bradshaw's conduct would be perceived as offensive. And those were your 4 conclusions.
Yes, sir.
Thank you. I'll pass the witness.
All right, Mr. Radner.
When you wrote your report, was it a thorough, complete, and accurate report?
I think so.
Okay, your analysis that you conducted was included in that report?
Yes.
In fact, it's pretty thorough. You explained exactly why and how what my client did constitutes harassment, right?
I think I outlined it pretty well, yes.
You did. I'll tell you did. Now, but there was something you just testified to a moment ago. You said that you also researched the First Amendment. Is that true?
Yes.
You researched this conduct in the context of the First Amendment protection?
Yes.
You know that there's not a drop of analysis in your report about the First Amendment?
Yes.
You know that the term First Amendment does not appear in your report?
Yes.
You know that the term free speech does not appear in your report?
Yes.
But you just told us that your report is a thorough analysis, it's complete and accurate, of your report is a thorough and complete analysis of what you did. How is it you can tell us under oath that you researched this in the context of the First Amendment, yet for some reason that analysis is missing from your thorough, accurate, and complete report?
The question was whether or not I considered the first analysis, or the First Amendment. I did. And I explained that I considered the First Amendment.
In your report?
My report was whether or not I believed the conduct violated the codes. And it does.
Oh, okay. All right. So what First Amendment analysis did you do? Did you research cases?
Certainly.
Which cases?
A lot.
Tell me one.
I can't.
Okay. Did you look up Houston versus Hill?
I don't know.
Okay. That's a case that's a Supreme Court case that actually says that if a municipality has an ordinance that makes it illegal to yell at cops, that's an unconstitutional policy.
I don't think they have an ordinance that says that.
Oh, okay. What is it that my client did which you feel was unlawful? Well, okay, let me ask you this. Did my client engage in any unlawful conduct?
Illegal conduct?
I said unlawful.
Under the terms of the ordinance, yes.
Okay, great. So what my client did was unlawful under the ordinance, right?
Yes, sir.
Okay. Mr. Frigerio has categorized that as disparaging, critical, criticizing, and the worst things you can say. Would you agree with those categories of attack?
I think in my report I outlined what they were. And I used the terminology, I believe, from the ordinance itself to describe this conduct.
Okay. Explain to me why this is not quintessential free speech. It was disparaging, it was critical, it was offensive, and all those things are exactly what the First Amendment is intended to protect. So
as you know,
wait.
You asked me a question, I wanted to answer it.
Mr. Radner, let him answer. Go ahead.
The question is, please explain that to us.
Okay. The first issue on the First Amendment is whether or not the individual was speaking as a citizen about a matter of public concern. As I explained in my testimony, I could not divorce him from his position as a counselor in addressing the officers.
Okay. Is there a single case that you can point us to? Statute, case, ordinance, anything that tells us that city councilmen are subject to a stricter scrutiny under First Amendment protection than ordinary citizens?
You're asking me whether, I'm not sure I understand the question. What I can tell you is that the city ordinance prohibits counselors from dealing with or instructing city employees.
Okay. So what I'm asking you is, under the context of the First Amendment, if let's say that ordinance applied to ordinary citizens, you would agree with me that it would be unconstitutional, correct?
Yeah, I think so.
Okay. So my question to you is there any case law, any statute, any citation you can give us at all, any legal authority that supports your position and Mr. Frigerio's position that a city councilman is subject to stricter scrutiny under the First Amendment for his speech than an ordinary citizen?
Just as anybody else is, the context and the forum make a difference. Certainly, if he was not, in my opinion, acting as a counselor, no. Not at all. But he was.
And your authority for that? Is it a case?
Everything I looked at shows I could not divorce him from his counselor duties. Not given the context and the timing and everything I just testified to. I looked to see whether or not he was acting as a private citizen as opposed to a counselor.
Okay. And is there, again, I asked you the question, you didn't really answer, I'll give you another chance, but then I'm going to move on. Is there any authority you can point to at all? Any authority other than you telling us everything I looked at? Is there any authority you can point us to that actually says that city councilmen lose certain free speech that ordinary citizens don't lose?
Not using those terms, no.
Excellent.
But certainly, they can be reprimanded, they can be disciplined, and there are a number of cases I reviewed where, in fact, that happened when they didn't follow appropriate protocol, etc. So, yes, their speech is limited in certain contexts and in certain forums.
That's true. During your investigation, did you investigate whether or not there's a Leon Valley police officer who actually was fired previously for kneeling on somebody's neck while he was handcuffed?
There was a Leon Valley police officer, I don't know if he was fired because they were kneeling on somebody's neck, but actually I think it was a hold down, but I don't know that they were kneeling on the neck. But again, I found out about that through your pleadings, actually. So during my investigation, no, that didn't come up.
Okay.
As Mr. Bradshaw said that he knew of no instance where that happened.
When is it that you? Well, you never interviewed Mr. Bradshaw, did you?
No, sir, didn't need to.
What did your investigation consist of? Did you say it was just reviewing the video and that was it?
A number of videos, and in my report I listed various things that I reviewed.
Okay, but it was just video? There was no interviews with people?
There were no interviews, no, sir.
Okay. And you believe that that's a thorough investigation?
Under this circumstances, yes.
Okay. Were you hired to be an investigator?
Yes, sir.
Who had hired you to investigate?
Well, according to the engagement letter, City Council.
You have an engagement letter?
Yes, sir.
Okay. And you're hired not to give advice, but to investigate. Is that right?
I was to investigate that complaint. Yes.
Okay. And there were some executive sessions that were held. Is that right?
Yes, sir.
What basis was there for? Now, Mr. Bradshaw, every time there was an executive session that involved you, Mr. Bradshaw requested that not be done in executive session, but an open meeting. Is that right?
No, sir.
You sure?
Yes, sir.
Okay. There were certainly some where Mr. Bradshaw asked for them to be for it to be discussed in public. Correct?
There was one.
Okay, there was one. And
He
yet
requested that any discussion regarding discipline against him be done in open session. And I said, that's fine. We're not discussing discipline.
So what is it that you were discussing?
We were in executive session. I'm not going to go into what I discussed in there, but in general terms, I was discussing my findings.
Well, now, hang on a second. You were not retained as counsel. You were retained to investigate. Correct?
True.
So,
but I am an attorney, and I was hired as an attorney.
You were hired as an attorney to investigate, not to give advice, not to give counsel.
True.
Correct?
True.
Okay. So then what attorney-client privilege exists?
Your Honor, objection. That's a privilege under the executive session. Any discussions in executive session by counsel and anyone in executive session is privileged.
Your Honor, my
Mr. Progerio, when you engage an investigator in an investigative capacity, the client, the way it normally works is then you're engaged in your investigative capacity. It's different than being engaged as an attorney. So what are you representing to the court about the capacity in which this witness was engaged?
The capacity of my specific objection is to executive privilege of executive session. No one can discuss any communication in executive session.
Okay.
Irregardless of whether you're attorney or chief of police or counsel person.
Okay. So that's a different privilege, Mr. Radner. What's your response?
It's not a recognized privilege. The way executive session works, and I'm actually a city councilman, so I'm very aware of how this works. You get to discuss attorney-client privilege. There's a very, very specific, limited list of things you're allowed to discuss, and it effectively comes down to attorney-client privilege. So I'd ask Mr. Progerio, for some sort of authority saying that you're allowed to go into executive session if it's not attorney-client privilege. Because I've never heard of any, and I haven't found it.
Okay. Mr. Progerio, what's your authority for executive privilege, which I assume is a creature of state law, applying in federal court on a federal cause of action under the Federal Rules of Evidence?
It's a privilege concerning the Open Records Act of the state of Texas, Your Honor. And any communication in there cannot be revealed unless there's a court order.
Okay. I'm going to cabin this particular issue because I don't think it's relevant to what I need to decide, regardless of what this witness thinks did or did not violate the First Amendment. He has no binding sort of authority over this court, which has to independently decide whether or not there is a First Amendment issue. So we can set that aside. I will tell you, Mr. Frigerio, that I'm sure you're very well aware that in federal court, not all of the privileges that apply in state court apply here if what we're talking about are federal causes of action, but I don't want to get into anything prematurely that we don't need to get into at this point. So, Mr. Radner, go ahead. I think we've gotten the position from this witness on why he thinks it violates the city's charter and why he did not have First Amendment concerns. What else did you want to ask?
There's one last topic that I want to ask about, and I guess I'll ask Your Honor if I can go there, and that is there a plan to throw Mr. Bradshaw out of office that was discussed in executive session?
All right. Well, why do you have to ask if it was discussed in executive session? I don't know that. I don't know that part of it. So, this is what we're going to do. We're going to take a lunch break until 1 o'clock. Mr. Frigerio, you can be prepared to tell me why I'm not allowed to get into those issues, given that the federal rules of evidence explicitly say that we don't observe privileges if we're here on federal causes of action that are only recognized under state law. So I need some authority for the federal courts applying that in the context of a First Amendment context. And Mr. Radner, and so we'll resume, and I will complete this portion of the preliminary injunction hearing, which concerns the First Amendment claim, after the next 45 minutes. And then I will tell you, we will get back on the record at 1. We have until 2, and then I have other settings, so I will have to recess the hearing at that point. I think I will be prepared to give a preliminary ruling. Mr. Frigerio, I'd also suggest that if there's any case that you have that actually relates to the First Amendment issues that we're addressing, the one that you cited earlier in the hearing, I have not had a chance to look at, but my law clerks tell me it's also in the due process context and not First Amendment. So that's where we are. We'll be back on the record at 1, and we're in recess. Thank you. All right, we are back on the record, and we're ready to resume. I think Mr. Sikowski was still on the stand, and Mr. Frigerio, you had objected to Mr. Radner asking about what was communicated during the executive session, and I asked you to be prepared to address that more specifically, so you can go ahead.
Yes, Your Honor, the case law that I had found, including Perry versus Spring Independent School District, it does circulate around the fact of attorney-client privilege. Now, if the city attorney was in there, it's pursuant to Chapter 551.071 of the Texas Government Code. But if the court were to conclude that he's an investigator, then that privilege may not apply. And in fact, if the court just overrules the objection, I guess he would be allowed to speak anyway.
Okay, that's my understanding, and I saw the Fifth Circuit case of Rush versus Columbus Municipal School District, which basically says the executive session privilege can be a common law privilege applied in federal court, but works, like you said, if that session is convened for the purpose of communicating attorney-client advice, then it can be privileged just like with the attorney-client privilege. But here, Mr. Sikowski is being proffered as a witness in the case, he's not acting in his capacity as legal counsel to the city council. He was engaged as an investigator, I assume, to do an investigation and to do conclusions. So I think his briefing of the results of his investigation if that was done during executive session, it can still be asked about. So go ahead, Mr. Radner.
Was there ever any conversation at all referencing in any way the removal of Mr. Bradshaw from office?
Not with me, no, sir.
In your presence?
No, sir.
Was it ever discussed as a hypothetical possible discipline?
Mr. Bradshaw sent me an email and asked what discipline he could possibly be facing. And I responded back, and I just copied the section, I believe it was from the charter. I sent that to him. The only other time I believe anything was mentioned was not in executive session. It was after my report was already submitted, and the mayor had intimated that she understood or believed what discipline was going to be initiated, and I reiterated to her that no one has ever discussed, and I've not discussed discipline with anyone.
Your testimony is that you at no point in time ever heard any of the defendants in this case say, imply, reference, suggest that Mr. Bradshaw would be removed from office. Is that your testimony?
Yes, that's correct.
Okay. Let me just ask you, how is a city councilman supposed to criticize a police officer?
Not as a city councilor.
So as long as he's a city councilor, he's not allowed to criticize the police?
Well, I need to correct myself. Criticize is different, I think, and that's what I struggled with, and I think was in my report, was whether or not he was dealing with officers. And in my opinion, in the context, the timing, location, he was, as a city councilor, dealing with the officer's performance of duties, not segregated and just generally criticizing the police force in general.
My question to you was...
That's where I came down.
My question to you was, how is he supposed to criticize him? Is he not allowed to?
Well, criticize is different. I didn't say he can't criticize.
So how can he? Obviously, going over to him and criticizing him, he's not allowed to do. How can he?
I didn't say that. I don't believe in context that he was simply criticizing the officers.
Oh, so what was he doing?
He was dealing with the officers.
Dealing with them?
In the performance of their duties, exactly.
Oh.
That's what the ordinance addresses.
Interesting, okay. I just have 1 second, please. So, I must have not understood your testimony before. What is it that he did wrong? I thought that and let me just tell you exactly where I'm going with this. Mr. Frigerio said disparaging, criticizing, critical, and worse things you can say, all of which are clearly speech. What I'm asking you is, what is specifically that Mr. Bradshaw did that took this out of the context of speech and put it into the context of dealing with?
I think everything I just went over earlier. He was at a city council meeting. He was directly outside of the city council chambers. He had not left. He was recognized as a counselor, a city council member, and he hadn't changed. He hadn't done anything.
But what was he allowed to do?
As a city councilor, I can only tell you what he can't do, according to the ordinance. According to the ordinance, a city councilor is not supposed to deal with city employees.
Okay.
If he has an issue with the employees, he's supposed to direct it through the appropriate, either city manager and then through the chief of police.
Okay. Obviously, the context of free speech is not something that can be regulated. So what I'm asking you is if Mr.
I beg your pardon?
The context, the words, the content.
Content.
Content?
Content, not the context. The content of free speech is not something that can be regulated by government. Assuming we agree on that, what I'm asking you is if Mr. Bradshaw wanted to say what he said, what would have been the lawful way for him to say it? To the mayor? Is that your testimony?
Well, there's a number of different ways. If I were him, I would have brought it up and I would have put it on the city agenda.
Okay,
That's what I would have done.
So right then
I would have done it in a public forum and had everybody there to talk about it.
So right then and there was no legal way for him to say the content of what he said? That's your testimony?
I think in the way that he did it, he was dealing with the officers. And in dealing with the officers, he went too far. That's what I think.
So there was no lawful way for him to say the content of what he said, correct?
Not in the way that he did it, at the time that he did it, no.
Thank you. Is there any authority at all that you found during lunch saying that city councilmen are held to this higher standard?
I didn't think I was allowed to go look at things during lunch since I'm sitting on the stand. So, no, I haven't looked.
No further questions, Your Honor. Thank you.
Nothing further, Your Honor.
Okay. Thank you, Mr. Sikowski. Mr. Frigerio, are you going to call another witness?
No, Your Honor.
Okay. Well, at this time, so this hearing, as I mentioned before, we're going to limit to the context of whether or not a preliminary injunction should be issued, or I'm going to recommend that a preliminary injunction be issued to Judge Beery solely enjoining the defendants from removing Mr. Bradshaw pending further proceedings in this case. There are a lot of other things that are involved in this case, but that's the question here. And so the question, as I'm framing it, is, has the plaintiff demonstrated a likelihood of success on the merits of his First Amendment claim, irreparable injury, and the other requirements related to obtaining injunctive relief in this posture? And so, Mr. Frigerio, I'm going to hear legal argument, but I'm going to ask a few questions of the attorneys, and then I'll let you do a little summary that gives me your position. Mr. Frigerio, my question for you is, it sounds like what your position is that Mr. Bradshaw, because he is a council member, no matter what he witnesses individual police officers doing, he may not directly address them. His only recourse is to go to the mayor or to somehow observe the chain of command. Is that correct?
Under the context of the time, place, or manner, I mean, this was outside of City Hall. But as once he's in his position, like Garcetti versus Ceballos, you're distinguishing between, are you in your position as an official or are you speaking as a citizen? He wasn't speaking as a citizen on the night of the incident in question. He would just come out of city council chambers holding the city council minutes in his hands, or city documents.
Okay, so Garcetti, as I'm sure you're well aware, that involved a public employee, correct?
Yes, a district attorney.
Yes. An assistant district attorney, no?
Correct.
Not an elected official.
Correct.
So you're aware that courts have drawn a distinction and held Garcetti inapplicable when the person is an elected official, no?
I think there are still distinctions. Excuse me. Apologize for the noise. There's a distinction if you're speaking as an official government employee as opposed to a private citizen.
But that dichotomy set up by Garcetti is different when you're talking about a public employee. So, for instance, that's the question I posed to you earlier in the hearing. If it had been a deputy who reported to the police chief, he wouldn't necessarily be able to go when he's engaging in his responsibilities as deputy, expressing his contrary opinions in various environments without suffering some employment consequences, correct? I mean, that's...
Yep.
But here, this is an elected official. He's elected. So, what he essentially is, I guess we could frame it this way, is a member of the minority party, so to speak, to the extent that the city council has a majority group of people who feel one way about some of these issues and a minority group. So, what the Garcetti rule, does it make sense in that context where the citizens of the community elected Mr. Bradshaw for his opinions? The majority party is allowed, you're saying, to remove him for expressing speech he disagrees with. They disagree with. You don't see any First Amendment problems with that?
Not when he's at City Hall criticizing an officer performing his duty, no.
So, a member of the city council cannot express contrary positions about policing at City Hall.
What we are alleging he did was harassing a police officer performing his duty. If he had again a problem under the charter, he needed to go to the city manager, the chief of police, not to address the individual employee.
Okay. And I have in the record, I mean, this isn't a case, luckily, where this is, I have to rely on different accounts of what was said and done. There is an undisputed account of what happened, what he said, and what didn't occur. And as I think your opposing counsel pointed out, you are taking issue. It is with the content of his speech. It is that he called their behavior disgraceful and disgusting, and it's the words. It's how. It's the content. It's not that you're not alleging that he in any way interfered with these police officers' ability to perform the arrest. They were in fact able to perform the arrest. So this is about the content of his speech, correct?
Harassing of the officer.
Well, you're characterizing it as harassing, but what I'm saying is whether or not something qualifies as harassment or not under a given policy is a different question, of course, than whether or not it's protected speech under the First Amendment. Many policies, if they're applied in the wrong way, could reach protected speech. That's the question that I have before me today. So I'm just clarifying that you're not criticizing the behavior. It is the speech, is the content of the speech. Nobody.
Yes, there was physical contact, correct.
Right. Okay. All right. Mr. Ratner, so why do you, I've made some of the points and asked these questions of Mr. Fraterios. Now I'll ask you. Garcetti is a Supreme Court case, of course. And it does make this distinction about when somebody's acting in their official and non-official capacity. What is the best precedent you can point me to that Garcetti would not be applicable in this context?
There's three cases I can point you to, but can I just make one statement before I do that?
Sure, go ahead.
Garcetti was not included in their response to my motion. Garcetti was not brought up before the hearing, and this is really procedurally an improper way to bring up the case. The court gave them time to respond to the motion, told them that they should have responded to it, and instead all they did was say, well, we hired somebody else, and therefore we're okay.
Mr. Ratner, regardless of whether they bring up Garcetti, I'm a federal court, so Garcetti is a Supreme Court case, and I've got to follow I'm bound by it, regardless of whether you all tell me about it. So, go ahead.
Okay, but as far as kind of being backed into a corner and having to do quick research, there's Wilson versus Houston Community College System, which is a Fifth Circuit 2020 case. What that case essentially held was that the Supreme Court has long expressed the importance of allowing elected officials to speak on matters of public concern. We have echoed this principle in our decisions, emphasizing that the role that elected officials play in our society makes it all the more imperative that they be allowed freely to express themselves on matters of current public importance. Other examples are Bond versus Floyd, 385 U.S. 116. It's a 1966 SCOTUS case, particularly pages 133 to 135, where it basically says that a state representative, that state action excluding a state representative from membership in the legislature because of statements he made criticizing the policy of the federal government in Vietnam violated the First Amendment. And there's Wood versus Georgia, which is a 1962 SCOTUS case, 370 U.S. 375, particularly page 392, which addresses a sheriff questioning the use of a grand jury investigation. And that also was a First Amendment case. I think the strongest case on point is probably Wilson versus House Wilson, the first case I told you, versus Houston Community College.
And what's the site on that one?
It's 955 F3D 490, and the page is 497. It's a Fifth Circuit 2020 case. And if this is really a determination that he was acting in his official capacity, then I would say factually that's just simply wrong. If you get up and say this is the position of the city, and this is something that all elected officials need to know, you can't speak on behalf of the city. You can't get up even on the dais and say this is what the city believes. You're allowed to express your own personal views, even in your official capacity. There are rules of decorum that can apply as far as when you get to speak, such as having to be recognized by the mayor. But I don't think there's any case at all, and Garcetti certainly doesn't say, that speech should be restricted such that you're not allowed to convey the content of what your thoughts are. And I don't see how Garcetti does say that.
Okay. I heard in what you were just arguing is your point that there are sort of two different issues. One is, was he acting as a private citizen or an elected official, right? Because it was after the meeting. And I can't tell which way you're arguing on that. But another is the point that different rules apply, or different types of free speech protections apply, or are more robust for elected officials than they would be for subordinate federal employees who are not elected, and who are serving often elected and policy-making officials. So make those two, tell me which thing you're arguing, or if you're arguing both in the alternative. Okay.
And I'm sorry if I didn't make that clear. Yeah, I'm arguing both. Exactly.
Okay. All right. So procedurally, I think I've sort of asked the questions that I need answered. I'm going to give you each an opportunity to make any brief closing remarks that you want me to make, or you want me to consider, and I'll give Mr. Radner a few minutes, and then Mr. Progerio, you can respond since he's the applicant. So, Mr. Radner, anything else you want me to consider, or any other argument you want to make?
No, Your Honor. I think it's pretty clear at this point what my position is and what our argument is.
Okay. Mr. Progerio?
Yes, Your Honor. I just have two other cases I'd like to submit to the court. Granted, none of these are city council members. They're still officials acting in their official capacity. Gibson versus Kilpatrick.
Are they elected?
Deputy sheriff.
Okay, so no.
Spoke to a district attorney regarding the sheriff's activities. They claimed that was a First Amendment violation. The core of the Fifth Circuit ruled that was not a Fifth Circuit violation. It was not protected under the First Amendment. In Wilson versus Trey at 787 Bedford 322 Fifth Circuit 2015. Ultimately, Your Honor, our position is that he was acting as a city councilman and criticizing an employee. That is against the charter. That's why he should be subjected to a Rule 312 hearing, which could do many things. It doesn't automatically mean he's going to be subjected to censure or subjected to forfeiture.
Okay, so just to be very, very clear, the injunctive relief that they're asking for today, and that you could agree to, that doesn't have anything to do with the hearing, is that you not remove Mr. Bradshaw, because that is the thing, that is the irreparable injury piece. That is the piece that if it occurs, then, I mean, if you hold a hearing and, you know, and certain evidence is presented and whatever else, that doesn't prevent the rest of this from going forward and getting sorted out. If you remove him and replace him, though, then we're in the same position as the Fourth Court of Appeals case that we were talking about before. So just in terms of what we're talking about today, the relief being requested is an injunction preventing the removal of Mr. Bradshaw, not the prevention of a hearing being conducted. Just making that clear. And that's why we're not, I mean, so just so that you understand, you know, when you are, that's what the decision will be on, and that is, I am not reaching any decision today based on the evidence presented, because we haven't considered it yet, on the question of whether or not there are due process problems with the proposed 312 hearing procedures. But the question today is, could the city, you know, could Mr. Bradshaw be removed for engaging in the speech that he engaged in that is undisputed and in the record? That's what I'm answering today.
Okay, Your Honor.
Okay. So just answering that question, it sounds like your position is that he can be because he can be. Okay. And he can be because you have a city charter that prohibits the direct communication.
Okay.
Yes. Well, right. There is a harassment provision, but you're interpreting the city charter that Mr. Bradshaw's specific conduct and speech on that day was not allowed to be directed to those police officers in that manner, and he can be removed from his position for doing it.
Yes, Your Honor.
Okay. All right. Okay, so my preliminary ruling is going to, so what my recommendation to Judge Beery will be that a preliminary injunction be issued preventing defendants from removing Mr. Bradshaw for engaging in the conduct that's in the record. A written rec will follow. We hope to have it out. It'll be out tomorrow at some point, probably late in the day. And because I am just ruling on that basis, you all should confer with each other, because what I'm trying to do here is to preserve the status quo. So, I mean, because here's the thing. Today was just about this particular incident. You know, there are other things in the record. There are other disputes between Mr. Bradshaw and the city council, other conduct that you all are talking about. You know, and so there is a lot of things to be sorted out. But pending you doing that, I'm going to recommend a preliminary injunction be entered. I think that you should confer with each other on whether you can reach an agreement about how you want to conduct a hearing. And, you know, given that the option of removing him immediately isn't on the table, if you're going to conduct the hearing anyway, or if we need to have another hearing, you know, to sort out what can and can't be done at the hearing and everything else. That is where the evidence that was presented prior to this hearing seems like folks hadn't had a lot of chance to go back and forth on it. This was kind of an emergency posture. But if the removal is off the table, and the hearing will be scheduled at some point down the road, you know, I think you all could potentially sort out some of those issues. But if you can't, you can request a second, you know, hearing to address some of these preliminary issues if necessary, or you may decide that those are things that can wait until a trial on the merits, as long as an injunction is in place that prohibits Mr. Bradshaw from being removed. So I will do a rec to Judge Beery that expresses the limited ruling that I have indicated today. You all have agreed that you'll file your objections. I guess there will have to be, my ruling will come down the 28th. You'll file your objections on the 29th, but before midnight. And then Judge Beery will either let the TRO expire or accept my recommendation and issue a preliminary injunction on this grounds that I have indicated. Okay. So that is the scope of everything. This is a little bit procedurally complex. I always encourage folks to explore options that get you out of this emergency posture and allow you to figure out ways to sort out your differences and get your merit stuff ruled on by the courts. But I think that this puts you in enough of a position to know what to do over the next few days. All right. Anything else, Mr. Radner?
No, Your Honor. Thank you.
Mr. Pagerio?
No, Your Honor.
Okay. Thank you. Appreciate counsel and all the witnesses who appeared. Thank you. We're in recess.